Hello and welcome to Absolute Trust Talk. I am Kirsten Howe. I'm the host of Absolute Trust Talk, which is our podcast here at Absolute Trust Council. And today, if you're watching, you can see that I have Madison with me again. We've been doing a little kind of a mini series on some of the things that we see happening to our clients after death. And we're trying to help you avoid those problems ahead of time. So we're going to talk today about specifically bank accounts and some of the trouble that clients get into with bank accounts. So Madison, let's just get right into, our clients know that they're supposed to have a trust and they're supposed to make sure their accounts are owned by their trust, but just kind of let's talk about why that's true and the difference between a trust and not having a trust.
Thanks, Kirsten. Yeah, so the point of having it in your trust is to avoid probate. The purpose of the trust, other than avoiding probate, is obviously directing where you want your assets to go. If you don't have a trust and you have a will, you can still name where you want your assets to go. But in California, a will still needs to be probated. Probate is it's the word for the law, the probate code, but it's also, we use it informally as the process that you go through to put a will through the court system and have a supervised execution of the will. And if you don't have a will, if you have nothing that names where you want your assets to go, the law, the probate code, says where everything goes. So it has a whole family tree of where all of your assets would go depending on who's alive at the time of your death. And it's the same court supervised process that happens with a will. It just goes according to the law as opposed to according to your instructions in the will.
Right, and but there is a threshold. Not everybody has to do a probate just because they don't have a trust. Let's talk about that, just as a reminder.
So the current threshold for probate is a total amount of assets. Could be cars, personal property, bank accounts, anything that doesn't have a beneficiary or is not in a trust, anything totaled up over $166,250 is what would trigger a probate. If it's less than that, we can go after it with other methods, and we can talk about that in a little bit. But if it's more than $166,250, which is pretty much one retirement account without a beneficiary designation, would trigger a probate. And if one item triggers a probate, all the assets that aren't titled properly or aren't in a trust, they all have to go.
Yeah, they all get dragged into the probate. Yeah. And this is the problem that a lot of what we see for our clients is not an infrequent problem. They often will leave a bank account outside of their trust, and that's really okay as long as it doesn't bump them over that $166,250. But what happens when the bank finds out that the person has died is they freeze the account. And so that's a problem. We have clients also who have been, acting under a power of attorney and managing someone's bank account for them while they're alive. But then, let's talk about what happens to that power of attorney when somebody dies.
Yeah, so when your power of attorney is good while you're incapacitated or while you're alive, depending on how it's written, but once you die, that power of attorney is now null and void. You do not own your assets anymore after you die. They now belong to your estate, which is just, a fancy theoretical thing, but you don't own it, so your power of attorney is no longer valid.
Right, and so we have on not many, but we have had occasions where clients continue, after the person has died, continue accessing bank accounts because they had been accessing them under a power of attorney while the person was alive. But I think that's not legitimate once the person has died. That power of attorney is no longer in effect.
Yeah, you can't use the ATM card anymore. You're not allowed to write a check. You can't even log into their online account. If I have an online account and something happens to me and I die, my husband can't use my login. as a power of attorney. He's got to, even as a joint owner, he's got to use his own login because all that stuff dies with you. So that you can't even use the money to pay for a burial or anything of that nature. You don't get to have access just because it's an emergency.
Right. Okay. And so when you're not allowed to access a bank account and you do it anyway, what is that? What do we call that as lawyers?
That would be illegal, and and it's also a breach of duty. We're not going to get into all the nuances when it comes to duties that you owe each other when you're handling finances, but there are a lot of them and a lot of nuances involved. But essentially, as your power of attorney, as someone's power of attorney, you have a duty to them while they're alive, and then once they pass away, your duty is to transfer those assets over to the administrator of the estate.
Oh, okay. So let's talk about that, because once somebody dies, there are a whole list of possible players who could access the account depending on what kind of account it is and how it's set up. So let's kind of walk through who those possible players are.
Sure. So the main one that you and I deal with would be the trustee, and that's the person named in someone's trust document that is allowed to take over once the creator of those documents passes away. They are generally allowed to access trust property, but sometimes they can access non-trust property if it's outside the trust and the decedent has what's called a pour-over will, meaning they left everything to their trust. So that's the first one.
And that's the standard solution. That's the solution we like to see happen to those assets that are left outside the trust, is the will takes care of them, and then the trustee can go access them.
Right.
There's a process. They have to comply with the process, but they are legally allowed to do that.
Right. Yeah. Without court.
Without going to court. Yeah.
The second is the person named the executor or the executrix, if it's a female, which is the person who's named in a will and appointed by the court as the executor of the will. So there's three titles for people when a will or a non-will goes through probate. You have the executor, which is the person who's named, and you have the administrator, which is someone that the court appoints that is not named in any document. So if a family member passed away and there's no one named anywhere, there's no documents, any family member that has standing, so essentially if you're set to inherit something by law, you can go file a probate. That would be an administrator. And then a personal representative is used interchangeably between executor and administrator. So it kind of just depends. Those little nuances in there.
Right. Okay. So if the person has died intestate and the family has to do a probate, the person who's in charge of the probate is going to be called an administrator. Whereas if the person had a will and they name someone as executor, the personal representative who does the probate is called the executor.
Right.
And Madison said, possibly executrix. That's a pretty old-fashioned term, but you still see it from time to time.
And you have to be appointed before you can access any of those accounts. And the court, they'll give you, if anyone's ever dealt with this, they say, I need your letters. I need your letters of administration. That's what they give an executor or administrator in order, that's their golden ticket to the bank.
Right. But that happens after you file the petition, and then the court says, yes, we're going to grant your petition. You are now officially the executor. And so this is something that clients struggle with a lot. They know they've been named as executor, or they know they've been named as trustee, but they still need to go through the process in order for the bank to say, oh yeah, we're cool. We're going to give you access to this account. It's about the bank. They've got to comply with the law. And so therefore the executor and the trustee also have to comply with the law, or the bank can't.
Yeah.
So now these bank accounts that our clients have trouble with can be set up in a variety of ways, and some are easier than others to deal with. So let's talk about some of the different ways that you could have a bank account set up.
The first one is good old-fashioned joint tenancy. That's mom puts, Junior on the account so that Junior can access the funds and help pay for things while she's getting older. And if they own it in joint tenancy, that means when she dies, it all goes to him. And that means all he has to do is provide a death certificate.
Right, and that we don't advise doing that except for small accounts that you're doing that for convenience purposes, because you're actually adding another person on as a co-owner of the account, and you got to really trust that person. And we have seen situations where a child got added onto account as a co-owner, and it was a large account, and that can really mess up the other children. Mess up the whole family dynamic. So, okay, so that's joint tenancy means two owners on the account.
Yeah, it is the simplest thing to do, but it also has the most pitfalls in terms of estate planning, especially if there's more than one child, or that child doesn't need that account to be against their name for any reason, whether it's extra assets or they have creditors. You don't want that they have equal ownership. Joint tenancy is equal ownership. Right. The other option is a pay on death or a beneficiary designation. Sometimes they call them POD accounts or TOD accounts, transfer on death accounts. And that is just like a retirement account where you list name a beneficiary on the account. So if you have an account set up like that, if your Chase account is POD, then your executor or your trustee can contact them, but they're going to say, this is a beneficiary account, we need contact with the beneficiary, and the beneficiary provides a death certificate, and they write a check or convince you to open an account at their branch, something of that nature.
Right. So that's pretty easy for the person who is named as the beneficiary to get that account. They just need to show up with a death certificate.
Yeah. And just to note, these pay on death accounts and accounts in joint tenancies, they do not go towards an estate. So they don't go to paying funeral expenses, they don't go to paying bills, they don't go to paying ongoing administration expenses, anything of that nature. They go directly to the beneficiary. You don't pass go, don't collect your $200. Like, it goes direct. There is no way to use that money for anything else.
Yeah, you can't make them contribute that to the funeral. You can't. It's theirs, and you can't require it. Yeah.
And then the next one is what's called a small estate affidavit. So earlier we talked about if you have a trust and the account is not in the trust, you can go and fill out what's called a small estate affidavit. Some financial institutions have their own, or you can have an attorney draft yours. Essentially, it would say, that, mom died. Her will says this is where it goes. This is the account. We swear under penalty of perjury it's under the threshold for probate, and 40 days have passed since she passed away. You sign it with a notary, turn it into the bank with a death certificate, and they will issue a check to the trust. If there is no trust, and then you have to say who the beneficiaries are according to the terms of the will. And if there is no will, then
according to the law of intestacy that we find in the probate code. Yeah. This small estate affidavit, it's interesting. I mean, this is something that we do in, would you say most of our trust administration cases have at least one?
And that's what we do, but everybody signs one when they go to transfer a title at DMV. They don't know that's what they're signing, but that's what they're signing. That's
essentially what they're doing to transfer the cars. Yeah, but I'd say it's easily over half. So I'm saying most of our trust administrations, there's a trust, but there is a bank account or something that got left out of the trust, and we do a small estate affidavit. That happens very often.
You see it a lot with life insurance policies or insurance policies where either there was no beneficiary listed or the beneficiary pre-deceased. So if it's the husband died first and the wife never changed her beneficiary designation, then there's no beneficiary, so it would be her heirs or her
Right.
trust, depending on the situation. So you see that a lot too.
Especially a lot of people, well, I don't know how many, but it's not uncommon for someone to have a small life insurance policy that they kind of forgot about. They've had it for many years, and the beneficiary died. And it's not the thing that you think about. Oh, my beneficiary died. I better go dig out that little $8,000 life insurance policy and take care of it. People just don't, remember to do stuff like that. So that's where that comes into play a lot, I think, is these small policies that people have owned, forever. They bought it thinking, oh, this will pay for my funeral. And,
like no one can get access to it to pay for your funeral.
that's a problem. Yeah.
Yeah. And 40 days has to elapse. So it's not,
Which doesn't usually help with paying for a funeral.
No. And then to be fair, also, CDs. People think, oh, I'll change that when it matures. Little CDs, $1,000 CDs sitting at your credit union just so you can have the credit union account for your mortgage or your loan. Those typically are not titled either.
Yeah. We see that a lot. Yeah. Okay. And then finally, as we've said, if you have the assets that aren't in a trust and they are above $166,250, that's when a probate will have to happen.
Yeah.
And we hate to see that. But, in some small percentage of our trust administrations, there's a trust administration and a probate. And that's just, that's the worst conversation to have with a client,
It seems like it's been increasing a little bit lately too. And I don't know if that could merely be because people are having difficulty getting into the banks because of COVID in the last year, but that's important.
Yeah, I think you're probably right. Okay, so let's, we've got a few questions in the comment section. So let's go right to those. Madison, I'll read them and then we'll both kind of pitch in and answer. Okay, so here's the question. My friend's mom died and only had $1,000 in an account that was joint between my friend and her mom. Does that mean she has to do anything else to administer her estate? Okay, so I think the question is, that's all she had was that $1,000 account. She didn't have a house. She didn't have a brokerage account, nothing. Is that, I think if we read the question that way, I know the answer, but I'll let you answer.
Yeah. There's not a whole lot of things that have to be done in that situation. There's no other beneficiaries. In theory, there's no other beneficiaries to notify or anything of that nature. But you do have to notify the Department of Healthcare Services when somebody dies. And it seems odd because it's the state of California and they would know that somebody died because the state of California issued a death certificate. But you do have to notify them. The Department of Healthcare Services is in charge of Medi-Cal, which is California's Medicaid. So you have to notify them just in case someone was receiving Medi-Cal. Even if they weren't, you still have to notify them. And they have 4 months to send you a letter saying this is what you owe or don't owe. And if you do owe anything or the decedent estate owes something, they can only collect that from a probatable estate. So in this situation, that $1,000 is joint tenancy. It's not a probatable amount. So there would be nothing for them to collect anyway.
Right. So in this case, the joint tenancy works nicely because now nobody has to do a probate. Nobody has to do a small estate affidavit. All you got to do is notify Department of Healthcare Services. And that every time somebody dies, Department of Healthcare Services has to be notified. A lot of people don't know that. So thanks for pitching that into the conversation. Okay, so another question. As power of attorney, can I use the account to pay for funeral expenses or the costs associated with opening a probate? It's not free. Probate court is not free. You gotta, there's at least at a minimum a filing fee, which is $435. But so the question, if I have power of attorney, can I access that bank account? Madison, I'll let you.
No.
No.
I don't know the
Don't
specifics,
do it.
but I'm pretty sure it is illegal and it's probably a felony. You know, I don't know if the dollar amount matters like it does with normal theft, but it's against the law and I wouldn't want to mess with that.
Well, right. And if you're talking about a bank account, the banks are governed by federal law. So you
Right.
might be getting into trouble with federal law, and you don't want to do that. So don't do it. There are better ways to do that. Okay. Again, another person asking a question about power of attorney. If I have the power of attorney, should I notify the bank that the owner has died?
Okay, so this one's kind of an it depends. It would seem like yes, you should notify them, provide a death certificate if you have one. However, if there's an ongoing trust administration, somebody owns a house, the utility bills come out of the account automatically, because one of the items that is typically not in a trust is the checking account that everything has automatic withdrawals and automatic deposits. So if all those automatic withdrawals are keeping the lights on in the house or making the mortgage payment, you probably don't want that account frozen, but you would want to communicate all of that information over to the executor or trustee or personal representative or administrator so that they can handle that as well. It doesn't mean you're accessing it.
You want to get those automatic withdrawals turned off before you notify the bank, because the minute they know, they're going to freeze the account, and now all these automatic withdrawals are going to bounce, and you don't want your mortgage payment not getting paid because the account is frozen. So that's a case by case thing. I guess it's the answer. Yeah, I like the very first thing you said.
Yeah, it depends.
Classic attorney answer. It depends.
It always depends. Everything's so fact specific. We can give generalizations, but
yeah. Okay. I think there's one more. Let's see. I'm having a hard time.
I can read it to you. Yeah.
Okay. Yeah.
Okay, so it says, my mom is the executor of her brother's estate. He unfortunately passed during COVID. My mom had settled his estate, and when should she close his bank account? So I think it would be after his final tax return is handled, assuming that everything else is completely done. Like if there was a probate, that's closed, or if a trust administration, that's all done.
Yeah, I mean, if she's the executor, it's no longer his bank account, it's
right.
the executor's bank account. But if the question is it okay now to pay everything out? I mean, if we always say hang on to some of the money until you file that last tax return. You just never know what's coming.
Yeah, I mean, with a probate, you get a final order from the court saying pay X, Y, and Z, $5, $10, $12. And so you know that, and then you have a reserve for the final. Right. If he had a bank account, and this is separate from the estate account that was opened after the probate was opened, then you could just move all that money into the estate account and close his personal account.
Right.
That's fine.
That's what you should be doing as the executor. Right. You need to close the decedent's accounts as soon as you get your letters. Okay, I think those are all the questions. Let me just double check and make sure I didn't miss one. I don't want to not answer questions if people are nice enough to watch us. Okay, so thanks, Madison. That I think was very informative, and hopefully our viewers got something out of it too. If you are watching live, if you've watched before, that this is recorded. It'll be on our website. You can watch it again. I know you want to do that, or you can tell your friends to watch it again. It'll be on our website, absolutetrustcouncil.com. It'll be on YouTube, on our YouTube channel. It'll be a podcast on our website also, and also wherever you get your podcasts. So thank you so much for joining us. We really appreciate our listeners and our viewers. If you like our podcast, be sure to go into iTunes and subscribe. You can find it by just typing in the words Absolute Trust Talk or my name, Kirsten Howe. It'll come up. You can see all of our previous episodes on our website. We've got a ton of episodes. We've got a ton of stuff on our website, absolutetrustcouncil.com. So please go and look and find things that will be helpful to you. That's why they're there. We're here to educate and help you. So thanks for watching, and I look forward to connecting with you next time. Thanks, Madison.
Thank you, Kirsten.